Welcome to It's No Accident, a podcast about the challenges of personal injury and wrongful death law in Florida, one of the nation's most complex legal environments.
You'll hear compelling stories about real cases from our law firm in Tallahassee that will help you better understand your rights and protect yourself from the negligence of others.
I'm Mark Nonni.
And I'm Jaeson Homola.
And this is
It's No Accident. All right, one of the things that we talk about and is a large driving factor in the value of a personal injury case is a lot of times people call them pain and suffering damages. That's not the only non-economic damage there is. Really, pain and suffering falls into non-economic damages, and it consists of pain and suffering, inconvenience, mental anguish, and loss of enjoyment of life. And those all fall under the heading of non-economic damages, and those are things that they're really tough to put a value on, and we get asked all of the time, how much is the pain and suffering component of my case worth? There's a lot of misconceptions that they're worth $1 billion.
Right.
And they could be in certain cases, especially if there's a punitive damages element. But can you talk a little bit about what pain and suffering damage or non-economic damages are and how they fit into a personal injury case?
Sure, yeah, absolutely. And like you said, it's definitely, I think, one of the main questions we get from clients a lot and one of the hardest to answer because kind of like you said, there's no real, the way I normally explain it to people, there's no magic formula that tells you exactly what the pain and suffering is worth in the case, right? And like you said, that's non-economic damages. For the economic damages, we're talking about like medical bills, lost wages,
sure,
stuff, out-of-pocket stuff. So it's easy to figure out what that is, right? You just add up the numbers, right? But for the non-economic damages, the pain and suffering stuff, like I said, there's really no magic formula, and it's, it's tough to figure out. Sometimes it's tough to explain, and really, I guess, first off, it seems obvious in the title of it, pain and suffering, but it's basically just money accounting for, all the crap you had to go through, basically, right?
Yeah.
Whether it's, the literal pain and suffering of your injuries, or just the inconvenience of your life. If you can't you can't do certain things you used to be able to do, now you have to get someone else to do them for you. You can't live your life like you used to be able to live your life, all those kind of things. And really, I'd say there's really kind of, in my mind, two different ways to look at it. One is how you would kind of try to evaluate it from a settlement perspective, like if
Sure.
you're at a mediation or something and you're trying to settle the case versus but then if you actually go to trial and you're in front of a jury and you're asking the jury for money for pain and suffering, you might think about it or present it a little differently, right? Sure. But I'd say generally one of the ways I try to explain to clients is, and this goes for the total value of the case, but also specifically the pain and suffering component of it. It's almost kind of like we do a lot of jury verdict research, and we'll do research into past jury verdicts and past cases, right? And then also research into settlements from past cases. And based on that, a lot of times you can get some idea of kind of what the amount of pain and suffering that you would typically expect for this type of injury in this particular location, right?
Sure.
And so it's kind of, the best analogy I think I've used over the years is kind of like trying to figure out what your house is worth. Like if you're trying to, an appraiser or property appraisers figuring out what your house is worth, so they're looking at, or a realtor or whoever, they're looking at the comps, right? The other comparable sales up and down your block. And it's kind of the same thing to some extent where we're, looking through the database that we, pay for access to that has jury verdicts on it and settlements on there and looking for similar cases. And we can see, well, if in those cases, the jury awarded this amount of money or the settlement was this amount of money, it gives you some idea of what would be in the range of being fair, right?
Sure. And I would say it's probably one of the most contentious areas of these cases that we have, especially if you have say you have a rear end auto collision and you've got admitted liability, the defendant's already admitted they're at fault. The two main areas that you're going to be arguing over is, did the wreck cause your injuries,
right,
number one, and a lot of times, especially if it's a pretty, if you broke your arm or you broke your leg and you had to have a surgery on it and it's clear cut, a lot of times that can be taken off the table as a contentious issue, and what you're left with is, and then, you look at the medical bills, those are pretty clear cut too. This is what the medical bills were, and the insurance companies a lot of times, they'll they'll try to wiggle out of some of them, but a lot of times the medical bills can be pretty easy to deal with. So in some of these cases, what you're arguing over is what the non-economic damages, pain and suffering component of the case is.
Right.
And insurance companies, the old quick and dirty way to do it is, they like to look at your medical bills and say, we'll give you 3 times whatever your medical bills are. Well,
Right.
that doesn't necessarily, I guess it gives you a framework if you're just looking for like a quick and dirty way to do it. But, doing this for so many years, it's really not fair. Because not every case is the same. And what you're trying to do with these pain and suffering non-economic damages is what you're trying to make the person whole. That's the theory behind non-economic damages. You take you try to give back to the plaintiff what's been taken from them to make them whole again.
Mm-hmm.
And unfortunately, if they are having trouble working around their house, or they can't go back to their job, or they're having trouble sleeping every night because they've got a back injury, or they've got this inconvenience where they've got to go to the doctor's office 2 times a week because of this injury that they've got, you can't necessarily give them anything that's going to make that better. So what our justice system has done, and the best thing that they've come up with, is to compensate you monetarily to, hopefully make things a little bit easier for
Right.
you. The old saying is that money can't buy happiness, and I agree with that. It can't buy happiness, but it certainly can make things a lot more easy
Sure.
in your life. And what these pain and suffering damages, non-economic damages, are trying to do is just make things a little bit easier for the person and try to make them whole and give them back what's been taken from them. And there's no perfect way to do it, and we're just going by what the justice system has come up with, the best way that they've come up with to compensate people fairly and deliver justice for something that's been taken away from them. If we're in even a settlement or a jury trial, what are some of the things that we're presenting to the mediator or to the insurance company or to the jury that would help us, boost up that value or evidence that there is value there?
Sure. No, absolutely. And before I go there, just going back to what you're saying, I agree in terms of that's the way our system is. That's really awarding money to compensate for the pain and suffering aspect is really the only logical option. You can't turn back time, right?
Sure.
You can't undo it. And so what else are you going to do? And like you said, it's getting justice, and it's the money is almost like an acknowledgement too, right? It's an acknowledging the wrong that was done to you. In the only way that we can, and it is just the concept of pain and suffering, and is sometimes in and of itself a contentious issue if we're at trial and we're talking to jurors, right? There are certainly plenty of people out there who just don't agree with the concept of pain and suffering.
Yeah,
right?
They just have a fundamental belief that there's no way that you can put a value on it, so I'm not going to do it.
Right, or like what or this is jackpot justice. Why do you deserve all
Right.
this money?
Right.
And so that's it's just, and I think the way you described it is one of the best ways to try to explain it to people, that this is not just someone hitting the lottery or something like that. This is money to do justice by this person and account for the wrong that was committed to them, and with the realization you can't undo the wrong, and all you can do is try to money's the only really thing we can do to try to help them out with it, like you said, make it easier. But in terms of the factors or the stuff that gets presented, to kind of the components of what make up the pain and suffering claim, I think the majority of it it comes from our client's testimony, either testimony of our clients or what we call before and after witnesses.
Sure.
Right? Friends and family members who knew him before the incident, knew him after the incident, and can testify to ways in which this incident, these injuries have affected their life. So what I mean by that is you have the client testifying about that during their deposition or at trial and explaining that to the jury, and then typically we'll have 2 or 3 of these before and after witnesses come in to typically not just reiterate exactly what our client already said, but kind of explain it from different angles, and
Give stories.
exactly. Right.
In a perfect world, it would be stories as to how this has affected the person.
Ways that the friend or the family member or whoever it is, ways that they've visually witnessed the impact it's had on their life. It's not saying, the plaintiff told me this or the plaintiff told me that. It's like, no, I was with my friend a lot before this, and I've been with him a lot after this, and here's the things I've noticed and I've seen that are different and that are affecting their lives in a negative way, and to just basically try to put something that's hard to put in words, so to speak, into like you said, make a story out of it and make the jury understand it. And so it can be difficult, though. I mean, there's definitely an art to it to some extent.
Yeah, some clients are very good at explaining this sort of thing and explaining how their injury has affected them and coming up with different examples of how it's affected them. Some clients, on the other hand, you really have to dig it out of them. So, and I mean, by and large, I would say a lot of our male clients, they don't really like to talk about their feelings. Right. They don't, they try to put on a tough face and,
be a tough guy.
Be a tough guy.
Yeah.
I've got a high pain tolerance. Doesn't really affect me. But then when you go and you talk to their wife, they're like, yeah, no, that's behind closed doors. That's not what this is like. Here's this situation. I can tell you where, it's really affected him and he can't do what he was able to do before. And like I said, I mean, sometimes you have to really pull it out of people, and that's where the before and after witnesses come into. Right. These folks that see our clients on a daily basis and can testify to things that our client doesn't even realize that this person is noticing about them.
Right.
They're testifying about just things that they've noticed and things that they can see that the other person may not even realize anybody else is picking up on.
For sure, yeah, no, and I agree in terms of trying to, in terms of some of the clients, tends to be more so guys not being so open about some of that stuff, when we're prepping the clients for their depositions or for their testimony at trial, and like you said, it's kind of like you have to pull it out of them, and it's almost, I feel like sometimes, almost kind of like a therapist where you're just trying to get them to, just open up. You know what I mean? Don't hold back. You're not doing yourself any favors by holding back. But yeah, no, and the before and after witnesses, I mean, I earlier I mentioned family members or friends, but which are good before and after witnesses, but really some of the better, best ones I've seen over the years are, people who are connected to the client, but not necessarily related to what, because, if it's like your spouse or your mom or someone like that that's coming in to be the before and after witnesses, there's an inherent bias there. Well, of course you're going to say something that benefits this person, you're related to them, versus if you get a coworker in there.
Yeah,
right?
Especially somebody like a spouse or a adult child that is going to come in and testify as to some of the things that they've seen, knowing that if their parent or their spouse gets a good amount of money, that there's going to be some benefit to them, an ancillary benefit to them because their loved one got money. So there's always that inherent bias there, and I think that's a good point. That some of the best people that we've seen are coworkers,
coworkers, people at church.
Church member.
One of the ones I can remember from a past trial was actually an ex-spouse. It was our client's. I think it was her. It was her ex-husband. Who they were divorced and presumably had some rough times over the years. They got divorced, but he was still came in and was very very well able to explain the impact that had on her, for sure.
And then interestingly, now that we're sitting here talking about this, I know you had a trial one time where there was actually a grief expert that came in and testified, and it was a client that had he had lost. I don't remember. He was already blind in one eye and lost the vision in his other eye, so he was completely blind, or he lost vision in both eyes because of the incident. I can't remember, but I do remember that there was a grief expert that came in, and he was a grief expert specifically for folks that had, were able to see at one point, had their vision at one point, and then lost their vision.
Right.
And he was able to come in, and it was really, I remember it was really powerful testimony for him to be able to come in and explain a lot of things that you don't think about.
Absolutely, yeah. I agree. I think it was very powerful too, and it was. You're right. Like you said, he'd already had vision issues in one eye, and then this incident happened, and it made him completely blind at the age of at that point he was in his 50s or 60s. So he lived his whole life being able to see, and then all of a sudden couldn't. And it's funny, not funny, but just it's like there's an expert for everything. It seems like, and you don't really think about it. And that was one of those things where it didn't even occur to me that there was somebody who's an expert in grief associated with blindness in, as an adult, basically. I mean, they're like I remember the expert was making a distinction between, someone who was born blind would be different than someone who became blind when they were a kid versus someone who's lived 60 years of their life and then becomes blind.
Right. I mean, because these trials, this trial is not happening 10 years after the incident occurred. So I think one of the things that he talked about was, look, the plaintiff in this case doesn't even realize the full extent of what he's going to deal with
Right.
in the future. And the expert, from what I recall, was actually blind, and kind of had gone through what our client was about to go through.
Right.
And he's like, look, you're in the first couple of years of this, you're learning certain things and going through the trials and tribulations of now not having your vision. 10 years from now, you're going to have a lot more to talk. The client would have a lot more to talk about in terms of those trials and tribulations, just because over time there's things that come up that you didn't even think about.
Right. Yeah. You don't even know what to expect yet.
And for somebody that has lived with it for 15 or 20 years after being able to have their vision, that expert was able to come in and really provide some powerful testimony.
Mm-hmm. And really, it's all a matter, kind of like we were said earlier, a matter of just trying to, help, especially if you're at a trial, help the jury understand what this person's going through. Sometimes you might have someone on the jury who's had a similar experience, but a lot of times you don't. And it's difficult sometimes to try to have the jurors put themselves in your client's shoes. Which is something we can't say at a trial, but that's basically what you're trying to do. And whether it's an expert like that, I remember a different trial we had, in a wrongful death. It was a wrongful death case where our client was the dad and his only daughter was killed in a car crash, and we had a different type of kind of grief expert who came and gave some testimony there just about not only the grief of losing someone generally, but also being your only child, and she was like 19, so young, and to try to help the jury understand the pain and that causes.
Sure. And yeah, if you've got to be able to explain it to the jury, because if you don't, they're, like you said, a lot of times aren't going to have the life experience to be able to relate with the
Right.
person, especially if you got a young person on the jury.
Mm-hmm.
You end up with, say, a 24, 25-year-old on the jury that's never had back pain before.
Right.
Or never felt sciatic pain, pain
Mhm.
running from their low back down into their foot. It's going to be very difficult for that person to even comprehend what kind of pain that is
Right.
if you've never felt it before.
And how much it can affect everything in your life.
Exactly.
Not just physically, but then once you're living with that pain for years and years and years, it wears on you emotionally and mentally, right?
And if you're in a bad mood all the time.
Yeah.
You're pissed off, and then that affects your relationships with everybody around you.
Exactly.
So.
Exactly. I know one thing, just in terms of, specifically at a trial and in putting value on pain and suffering, obviously at a trial, it's up to us to, typically suggest a number to the jury.
Sure.
Right. And basically, ask for an amount of money, which is always tricky because, a lot of times, like I said, there's no formula for it, right? There's no formula the jury can use to figure out what's it worth. And so you're essentially, you're in a position where your client's testified, you've had before and after witnesses or experts and all these people to explain to the jury, what this person's had going through, but then ultimately you got to put a number on it. And a lot of times, you want to be able to have some reasonable basis for that number. You don't want it to come across like you're just picking a number out of thin air.
Sure.
Right. And that's always a struggle we, all deal with in terms of how to deal with that, how to come up with some type of, where did I get this number from? Right. What are some of the stuff that you've seen in that regard?
One of the most powerful ways to do that is look at it from a job standpoint. Like if someone were to put a wanted ad in the class, like I guess this is from when I was younger, but there used to be classified ads where you would put a want ad in the newspaper, and you'd be looking for if you were looking for a job and someone were to say, I'm offering this amount of money. On an hourly basis, all you have to do is, let me injure your back and not be able to do this, that, and, not be able to sleep well at night, not be able to move the way that you did before, and you're going to have to deal with this 16 hours a day. You know, what amount of money would it take for you to accept that job? Well, a lot of people would be like, well, I just wouldn't apply to that job because I wouldn't want to do it. But, you know, what we do is, we then say, look, we think, $15, $20, $25 an hour would be an adequate amount to compensate for that. And then we extrapolate that amount over, a lifetime. And that's where the mortality, I think we've talked about mortality tables. That's where those come in. And you come up with a number that way. And for the folks that are on the jury that say, well, you can't put a time or you can't put a number on that. The way that I combat that, and I say, well, we do it all the time. We put a number on our inconvenience. There's a convenience factor to everything. We put a number on our time. We're willing to do a certain job for a certain amount of money. And one of the ways that I've explained this to the jury, and anybody that's been in an airport can attest to this, when, as happens very often now, flights get oversold, and you're sitting in the airport, and the worker at the microphone says, "Look, we're oversold. We need some people to volunteer to go on the next flight." And they're like, "We're offering a $250 voucher for anyone who will do that."
Right.
And everybody looks around and nobody does it. And then it goes up to 300 and 400 and 500 and 600. And everybody's kind of looking around as the number goes up and nobody's going up there. And then finally there's a breaking point where finally, one person's going to cave and they'll be like, "It's worth it to me to do that."
Right.
And what they're really doing is saying, my time and my inconvenience is worth this amount of money that you're offering as a voucher. So the people that say that, we don't put value on those things, I say, well, we do. We do it in everyday life. We just don't, we don't think about it in that way.
This is just a different context, right? Yeah, for sure.
But it is difficult. It's probably one of the most difficult things that we have to do and have to explain, especially in a jury trial, because there are a lot of biases against pain and suffering, non-economic damages, and putting a value on it.
Yeah, no, absolutely. And I guess from a different perspective too, one of the things I think, kind of shifting gears a little bit, but still on pain and suffering, I think, a lot of people are familiar with pain and suffering generally. A lot of times when we get clients come in, they're maybe generally aware that if you have an injury case, part of the settlement is going to be pain and suffering. One thing that's a little, I think, unique to Florida, and that a lot of people don't really realize, is with regard to the permanent injury requirement for a car wreck case, right?
That's a great point.
And basically in Florida, we're a no-fault state. You have to have personal injury protection coverage. And basically the law says if you get in a wreck in Florida and you get hurt, the only way you're entitled to any money for pain and suffering is if you have a permanent injury, a permanent scar, or you get disfigured, right? Meaning like you lose part of your body, right? And so I guess the point is, a lot of people think, I got in a car wreck and I got hurt, I'm automatically going to be entitled to some money for pain and suffering, but that's not the case. I mean, the only way you're entitled to any money for pain and suffering is if you can prove one of those three things. And if you can't prove one of those three things, you can still get money for your medical bills and your lost wages, but nothing for pain and suffering. And that in any car wreck case in Florida, that usually becomes
a huge point
one
of
the big thing, right?
Yeah, unless you have a broken arm with a surgery, and even if you have a broken arm, I've had cases where they're like, yeah, she broke her arm, but they put it in a cast, and now her arm's fine.
Right.
Like there's no loss of range of motion or anything. There's no permanent injury there. They're like, well, yeah, but she broke her arm and had to have surgery, and there was pins and needles in her arm, and that arm's never going to work the way that it did before. So that's not as contentious as typically the case where we see a lot of contention is on like a herniated disc, soft tissue, herniated disc sort of case, especially if the person had gone to the doctor in the past and said that they had back pain or neck pain. Huge point of contention. There's always going to be an argument from the defense that there wasn't a permanent injury.
Right.
But that's a great point, because if you can't prove that permanent injury, and it's a question for the jury, if you don't prove permanent injury, you get no non-economic damage, pain and suffering damages. Yeah,
absolutely. And even like when we're at a mediation, talking about settling a case, I know that's a lot of times, something that takes a little while to, normally I would try to explain to the client before we get to the mediation, but inevitably when we're at mediation, it always comes up again, and just trying to, make sure the client understands, like, part of, the it's not like there's just everybody's on the same page where this person's automatically entitled to money for pain and suffering. Part of what's going on in mediation is there's an argument over, are you even going to be able to prove that and get any money for pain and suffering, right? And it's difficult. And like you said, I agree. It's usually, most contentious with neck and back injuries, because that's also probably one of the, I'd say, most frequent injuries you see in a car wreck case, right?
Yeah.
And it's also tough because it's not same with like a head injury too. It's not an injury you can really see.
Yeah,
and the
from MRI films are very difficult for a layperson to understand.
Right.
I don't know. I mean, we look at them all the time, but sometimes I'll show them to my client, and they'll be like, "What am I looking at?"
Yeah, exactly.
And you even like the slightest, tiniest little amount of change in a disc, there's so much, like, there's no room for error in your spine. So like even a little tiny millimeter change in a disc can cause just huge issues. So. Yep. Anyway, pain and suffering, difficult, difficult area that we deal with all the time.
This conversation continues and much more on the next episode of It's No Accident.